What would you do if you bought a food product and it made you sick, really sick? Would you sue the manufacturer? Well, not so fast. As first reported by the New York Times, General Mills is trying to limit any future financial awards from litigation. Eamon Javers has more on a new policy which could spread.
Click on the General Mills website this week and you'll see some new legal boilerplate. But that fine print could have huge implications for people who buy General Mills cereals or other products. The new language says if you use any of the company's sites or services, including simply logging on to generalmills.com, that means you're bound to a restrictive set of legal terms. And those terms say you'll take any dispute you may have with General Mills to a binding arbitration, not a United States courthouse. Companies like this kind of negotiation because they're more likely to prevail in arbitration and they don't face the kinds of financial damages they can suffer in court.
If it tries to do something wrong, if it does something wrong or causes harm to its customers, it's basically trying to shield itself from any responsibility, and shield itself from any legal action, and so it's a little upsetting.
But General Mills says the new boilerplate is simply routine. This is being broadly mischaracterized, said a spokesman. The policy would not and does not preclude a consumer from pursuing a claim. It merely determines a forum for pursuing a claim, and arbitration is a straightforward and efficient way to resolve such disputes. Lawyers I've talked to today said that the company might be pushing the legal envelope here with this interpretation of the rules, but they may have one thing going for them, and that's the Supreme Court, which has been very friendly to arbitration cases in recent years. For Nightly Business Report, I'm Eamon Javers in Washington.
We turn now to Michael Deutsch for a legal analysis of what this all means. He's partner of the New York law firm Singer Deutsch. So, Michael, you just heard in our report that General Motors' reaction was that this boilerplate is routine, and we all have signed a similar agreements with credit card companies, with cell phone plans. What is General Mills doing that's different than those agreements?
Well, they're actually just moving the ball a little further down the football field because these agreements are becoming more and more common as a result not only of industry's preference for them, but the Supreme Court, as referenced in the report by Eamon there, has over the last several years come down with 4 decisions which have made it easier for companies to continue to grow this mandatory arbitration part of dispute resolution rather than taking things to court.
Go ahead, finish your thought there, I'm sorry.
So I think we're going to see more and more of it, particularly if General Mills, let's say, gets away with this in not only the public realm, but in the courthouse.
So what would their legal justification for be? If I happen to go on their website, that's one thing. But if I happen to consume one of their products and it injures me, has nothing to do with what I did on the website, how can they justify removing my right to take them to a U.S. court to allege injury? I don't get it.
What they're doing is actually basing their decision to do this on these recent court decisions that I've just referenced. Over the last several years, there have been 4 major court decisions at the Supreme Court level where the Supreme Court has said that consumers or small businesses do not have the right to opt out of these mandatory arbitration agreements that they've either signed or agreed to through direct or indirect means. For instance, if you have a credit card and your credit card company sends you your statement, and before you can open your statement, it says you need to click through to our new terms and conditions. You click through, you don't read any of it, you've suddenly agreed to mandatory arbitration. The Supreme Court has said we're going to enforce that. And so what General Mills has done is they've looked at this and they've said, hey, we think we can make this work for a variety of different ways that we're interacting with consumers in social media, when they're coming to our website, or when they're buying our product. And they're pushing the envelope to see if they can get away with it in the courts.
All right, so do you think that this is going to spread to other companies? They're seeing what General Mills is doing, and other companies, whether it's a car company or a drug company, will do the same?
I think over time it is likely to happen, but certainly there are going to be 2 important factors that other companies are going to look to. The first is what is the consumer reaction to what General Mills has just done, because they're the first company to really step out and say, we're going to be very aggressive with what we can do right now. And the second thing is what happens in the courthouses, because there are going to be a variety of lawsuits over this. That's for sure. And once those wind their way through the system, at the district court levels around the country, you're likely to see a variety of different decisions. Those will be bumped up to the Court of Appeals, and then maybe eventually to the Supreme Court for resolution on this issue.
So let me play the devil's advocate, Counselor, and say, why shouldn't a company be able to say, you use my product, you play by my terms, you got a problem with my product? We'll dispute it, we'll resolve it, but we'll resolve it in front of an arbitrator, not a court. Why can't I, as a seller or a business, be able to make that rule one of my rules of doing business?
Well, it seems that based on the recent developments in the law, that may be actually the case over time. But traditionally, it's been part of a negotiation between a consumer and a company that we are going to engage in a transaction, and as a result of that transaction, we're going to agree to these terms. Whereas in this case, you're just buying a product, you have no idea about what the privacy policy is on the website, and you're suddenly bound by these arbitration rules. And so this is really going to have to be resolved by the courts.
Real quickly, what could be a trade-off for a company like General Mills, a consumer backlash? They won't buy their Cheerios anymore?
Well, certainly you could buy a different form of Cheerios. Lots of companies are making Cheerios. I think the real issues are what is the effect on the consumers? Because consumers, if they're in arbitration, there are several handicaps aside from several advantages. And the advantage of going to arbitration is it's usually quick, it's inexpensive, you get a result, and you can both parties live by that result fairly quickly, much faster than the courts. But on the other hand, you're often giving up your right to punitive damages. There's confidentiality surrounding this, so the company is getting dramatic protection for mistakes it may have made in the course of producing its product.
Oh, sorry, we got to go. But fascinating conversation. Thank you so much. Michael Deutsch with Singer Deutsch.
Thanks very much.